Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damon. This episode is sponsored by the Imperial Museum of Modern Art. Now on display, the Thrawn Collection, featuring the only surviving works of art from countless worlds.
And welcome back, and thank you to the LGG Cantina Band, Lorem Ipsum, and the Scriveners, and thank you to our sponsor. Kirk, I think we have an art museum today as our sponsor.
Yep, hopefully everybody's been and visited that art museum. If you haven't, you might want to go check it out.
Yeah, and any other worlds you need to visit and see the art before it disappears. I'm your host, Ben Siders. With me here is your other host, Kirk Damon.
That's Kirk as in the Captain of the Enterprise, and not as in Russell.
Not as in Russell or Warner. This is episode 10, and as you may have gathered from the intro, we're going to talk about art, specifically fan art. This question comes to us from Mike S. on Facebook. Mike's an old college buddy of mine. Mike asked this back in August and has been waiting patiently for 3 months for us to talk about it, so thank you, Mike. Two issues here. One, can you recreate art that somebody else has already made? And then two, can you create new art based on or inspired by existing materials, like painting a favorite character from a book or something like that?
And I think it's worth pointing out in some sense, if you guys listened to the last episode, this is going to tie a little bit back into our last episode.
It's kind of a variation on that theme.
Because fan art in some sense is a little bit of a modification. I mean, there we were talking much more about modifying specific things that are out there, and this one we're talking about really sort of wholly created works, but these are wholly created works based upon something
and some
else.
of the same rules are going to apply. I mean, there's an argument these are derivative works, and there's arguments for fair use, and there's arguments that in some cases what you're making is not infringing a copyright because the original material, that aspect is not copyrightable at all. So, as you may have gathered, this is yet another copyright issue. We should coin an acronym for that, YACI, yet another copyright issue.
Then we start to sound like the internet.
Yeah. So a little background on, this is probably a good topic to kind of dig in a little bit more into mechanically how copyright works. I think copyright's probably the IP that the average person is most familiar with.
I'd say people are probably the most familiar with it. It's probably the one they understand the least,
That's
though,
the
too.
thing. But you probably mistakenly think you understand it the best. So,
I'll actually just to jump on that point real quick. There's actually was a legal article that just came out recently that interviewed people on sort of their general understanding of IP law. And one of the things that came out of it is the fact that they horribly misunderstand it and actually do a little better than random in answering IP law questions. Hopefully by now, having listened to 9 of these episodes, you're a little better at it than the average person is. But it's worth noting that even though people may think they have a lot of understanding of copyright, that understanding may be flawed.
Yeah, there's sort of a pervasive notion that copyright's about attribution rights. And although there is an aspect of that, plagiarism, there's an aspect of that. But plagiarism is what we learn not to do in school, whereas copyright is about not doing certain things with properties that don't belong to you. So why do we even have this is a good question. So you got to think back to prior to the invention of basically the printing press, there really was no such thing as a copyright because you just didn't need it. Expressive works, such as they were basically books. And
at least anything that was in permanent form.
Yeah.
I mean, you had plays, but those are all, temporally limited.
Yeah, and books were laborious to produce without a press. It was all done by hand, mostly by monks and religious scholars. Most people weren't literate anyway, so your audience was pretty small. There's just no reason to make them. And most of your literate people were part of universities, governments, or the church, which at the time was all just the church.
Yeah, in some respects, yes.
Yeah, so it's probably no coincidence that most surviving texts from that time are I'm thinking like the medieval era, pre-printing press, mostly religious in nature. But the press changed all that because suddenly you could make copies of stuff relatively rapidly and inexpensively.
Yeah, and I think that's one of those things to sort of keep in mind is when the printing press as a technological change in many respects, dramatically altered something which its technology had nothing to do with. I mean, technologically, it's a press, it's a machine, but the ability to suddenly produce works and produce literary works created two unique things. One of which, it enabled you to reproduce existing works much more readily. So, existing religious texts, stuff like that, simply became more common. Mm-hmm. The other thing it also allowed you to do is it allowed you to create works that were sort of less important, so to speak. And you can say what you will about, in conjunction with religious texts and whether or not they're, important to the world as a whole. But if you obviously take sort of the medieval era, religious texts were the important texts. And that's the reason I think also a lot of them survived, is because that's what was worth spending the effort to create. When you suddenly get rid of that barrier to entry, you can create works that aren't.
Yeah, it's interesting. Well, so I have an English degree, and I took a course on medieval literature and a course on Renaissance literature. Medieval literature, almost without exception, is either about religious figures or written by religious figures.
Yep.
When you get to the Renaissance...
Now, part of that's the literacy issue.
Part of that is, but then you get to the Renaissance, and setting aside that we have the Enlightenment kind of around the same time, you see a massive broadening in the scope of what is written. You know, how many works of Shakespeare are there that have survived?
Yep.
Dozens and dozens and dozens. How many works of any author pre-Renaissance have survived? I mean, most people wrote a couple of things, maybe. I can't think of anything.
Yeah. And a lot of it was also copying. I mean, that was the thing, is that, the vast majority of texts needed to be copied because text break down, they're destroyed.
Yeah, destroyed, lost in wars, so there's a lot of interesting historical aspects of that. But, when the printing press was first kind of rolled out, the Crown controlled the Printers Guild. We're going to talk about the Anglo-American legal tradition here. And since the Crown controlled the guilds, they controlled what got printed. As I alluded to, we had the Enlightenment, and people realized this is horrible and dangerous.
Yeah, when we think about the idea of a free press, it's kind of interesting when you think about the idea that the printing press was really considered horrible and dangerous.
Yeah, so the rule was changed in the United Kingdom really a long time ago, the early 1700s, in something called the Statute of Anne, and that was where the modern concept of the copyright probably originated, and that concept was basically imported wholly into the Constitution when the framers wrote it.
Yeah, and that's one of the things to keep in mind, and it's one of those things as an IP lawyer I actually really enjoy always pointing out to people, is the fact that the right to copyright and patent is actually in the Constitution. It's not an amendment to the Constitution, it's in the Constitution.
Yeah, the Bill of Rights was added on later. Yeah. The copyright right was always there.
Yeah, and so it's sort of an interesting sort of thing when you think about it, is that this is something that the founding fathers from the very get-go saw as being important, that there be a copyright, there be a right in inventions and discoveries and works and stuff like that. So
that groundwork's helpful to have because it explains some of the weirdness. I was talking to another lawyer friend of mine who practices more in labor. His name's Adam. So Adam, if you're listening, hi. And his comment was, I've listened to some of your episodes and I've come to the conclusion that IP is incoherent and psychotic. And from the outside, we're so deep into it, that I'm so familiar with it, I don't see it that way because I understand all these doctrines now. But when you first start getting into it, it does kind of seem that way. And copyright's a classic example of that because we have this institution built on the back of the printing press that we're now applying to motion pictures and sound recordings and things like that, player pianos and iPods, things that were not in any way in the contemplation of the authors of this institution.
There's actually there's a book I read a number of years ago. I can't unfortunately remember the author's name, called Copyright and Copy Wrong. And what's interesting about it is that contemplates, and a lot of the theory it has in conjunction with copyright, is how many of the strongest copyright defenders actually learned their trade by being copyright infringers.
Well, that's a classic tradition. Like we talked about this in our cloning episode. When you go to learn how to make video games, what do? You just clone one that you've seen before. Yeah. And when you're learning how to paint, even in art school, you paint public domain, mostly works, to learn how to paint and replicate these styles.
Those are museums from people in the Renaissance, so those would definitely be public domain.
Oh, for sure. And then there's always that fine line between homage and ripping off.
Yeah.
Common in movies. How many times do people copy styles or cinematography used in film? So this applies to fan art in IP because it goes to the heart of what exactly the copyright lets you do or not do. And the copyright itself is really a collection of, we call it a bunch of sticks in the bundle. It's a collection of negative rights on other people, kind of described as exclusive rights. What that really means is nobody else can do it.
Yeah, and I think that's the key way to think about it is it's the copyright grants the copyright holder the exclusive right to do certain things. Now, that means that they have the right to do it, but conversely to that, it also means other people do not have the right to do it.
It's also important to understand not everything you make is copyrightable. So there's an originality requirement, which doesn't mean it has to be completely original, like you came up with it, just that it has to come from you and not be something you took from somebody else.
There's also some interesting things in conjunction with originality of exactly who did it come from. I mean, you guys have probably seen the cases, the monkey selfie, some of the issues out there of exactly where the creator of the work becomes a little bit confused. Something that I think is getting to be a little more interesting today, in today's day and age, as we're starting to get into the concept of AI.
That may be why
talking about soon.
That may be why people confuse copyright with plagiarism, because if you plagiarize something, you can't get a copyright to it because you didn't come up with it. You don't have the originality requirement.
Yep.
But the mere fact that you've borrowed ideas from somebody else does not mean you've infringed a copyright.
Yeah, and I think one of the things, and it's I think important part for this episode to definitely get across, and something for all the listeners to definitely understand. Attribution and the fact that you attribute that you got something from somewhere does not protect you from copyright infringement. And I think that's a very, very important concept to get across, because a lot of people look at it and say, but I said it was theirs. Yeah. And the answer to it is that doesn't necessarily protect you from copyright infringement.
Simple intellectual exercise. So you photocopy all of Harry Potter. Okay, and then you go out in the street and sell it and say, by the way, I didn't write it.
Yeah, because J.K. Rowling's name wrote it, and her name is on the cover.
Infringement. Yeah. Sorry. Yeah. So to get a copyright, it has to be original. It has to be creative. The creative threshold in law is extremely low, and it has to be. They call it fixed and a tangible medium of expression, which basically means you have to be able to prove that you have it. So,
yeah, the fixed and tangible medium is actually one of the more interesting things when you start talking about things that are sort of borderline copyright and interesting. I know there was a huge issue in conjunction with jazz music, and the issue of that jazz music is essentially created on the fly. By definition, that's what jazz music is supposed to be.
If it's not recorded in some form, then whatever you improvised is not really copyrighted.
Yeah, and that's a really interesting thing. Now, obviously, if I set it down on a record at that point in time, it would be, because now it's fixed in form. But there's some weirdness about that sort of tangibility. Similarly, when we start talking about the idea of like a culture with an oral tradition and storytelling oral tradition, what do you have in conjunction with copyrights there, where the work is never really written down, it's passed on verbally, and particularly because, as we've all played the telephone game, you're going to have changes in conjunction with that. There's some really interesting sort of components of that. Tangible medium can create interesting questions.
And then the last component is you don't actually have to do anything to have the copyright in the abstract. I'm looking at a sheet of paper that's got our show notes. If there's a copyright in this, I now own it because I wrote it down.
Yep.
And people often, I was watching a Parks and Rec, and if you've watched that show, there's Adam Scott plays sort of a nerdy character who invents a game called the Cones of Dunshire. And there's a minor plot point where he never does register or get the copyright on it, which is a mistake because he has the copyright to the extent there is one once he makes it. He doesn't have to do anything.
Yeah.
Now you can register it. You should register it, but people often come to us and say, how do I get a copyright? I'm like, well, if you made it, you've already got it.
Yeah, and it is an important thing to keep in mind. It's actually one of the difficult areas of law is the fact that copyright, because it does attach without registration, it can oftentimes be difficult to figure out whether or not something is copyrighted, and if it is, who owns the copyright in it. And interesting enough, I think IP attorneys love to pick on Hollywood at times, because the number of Hollywood plots that involve somebody protecting an unregistered copyright is sort of like, hold on a second, they don't actually have to do anything.
So what does a copyright let you do? There's a lot of different things depending on what it is, but for our purposes today, nobody else can make copies of whatever you've copyrighted. Nobody else can, and notice it says make copies, period. That means even if you just make a copy and it sits in your office, you violated that right. Distribute copies to the public, which would raise questions. When you go to Barnes & Noble and buy a book, didn't they just distribute a copy of somebody else's copyrighted material to you? Where do they get the right? And the answer is a contract. The right to make derivative works, which we've talked about in the last episode and we'll get into today. And then another interesting one, the right to publicly display or perform visual or dramatic works.
Yep.
So if you buy like a screenplay, even if you buy a copy of it, that doesn't necessarily mean you have the right to perform it.
Yeah, and there's an interesting interplay when you start talking about particularly music and movies and things like that, and what I oftentimes refer to as sort of temporal works. So these are works that have to exist across time. So a book exists as one object, in a single point in time. Music and as music as it's heard, not so much on an LP, but
video
music
games.
as it's heard, video games, movies, anything along those lines kind of exist temporally. And you get into some interplays of the fact that there's a lot of different copyrights that play into them. So there's a right to the physical script of a movie. There's the right to the performance of a movie. There's the right to a particular performance of a movie as recorded on videotape. I'm dating myself here. Or sent to you via Netflix. And there's also an interesting interplay between music and music called a synchronization right, which is putting music to a moving image.
Yeah, we'll probably do a whole episode on that because the different copyright rights that exist in music and audiovisual works are complicated. I still have to refresh my memory on them because it's such a mess. As applied to fan art, these rights are pretty broad, and some of this is pretty straightforward. So as far as just I'm going to draw a copy of an existing work, clearly you've made a reproduction.
Yep.
So that's at least a technical violation, and those things are rampant. I was a sort of an amateur cartoonist when I was in high school. I can probably still spit out a pretty solid Garfield if I needed to. Every one of those I drew was at least technically a violation of Jim Davis's rights to Garfield, because I made a reproduction of his character and his.
Now we're getting a bit into character copyright, which I specifically about the reproduction of Garfield as opposed to reproduction of Garfield in a particular strip.
But I learned to draw Garfield by sitting down with books and just looking at it and then reproducing it. And I used to do the same thing with dragons and magazines and stuff like that. But there's a practical thing here. How's anybody going to know? You know, is Jim Davis going to come sue a 12-year-old for drawing Garfield? No, these people are artists. They're creative types, and they understand that this is how they learn to produce this stuff. And unless they're extremely heavy-handed, this is probably no harm, no foul.
Now, again, I think the thing to keep in mind in conjunction with this, we look at it and say there's probably no harm, no foul, but it's entirely dependent upon the copyright holder saying, I'm okay with this. So in some sense, there's an implicit contract, or there is sort of a contract.
Or just a voluntary decision not to enforce under certain circumstances.
At the same time, it is a technical violation. And I think that's one of the things to really keep in mind in conjunction with this is when we're talking about a lot of the fan art stuff, we need to focus on what is a technical violation more so than what's a violation that's going to get you in trouble, because the technical violation is the interesting point of law.
Yeah, there's what the law permits and doesn't permit, and there's what makes sense on a business level to enforce or not enforce. And what the law doesn't permit, in my experience, is much broader than what businesses and content owners ever bother to mess with.
And that's true under all areas of the law.
Yeah.
I think it's, this has nothing to do specifically with IP. What is permitted underneath labor law is not necessarily what a business is going to do. They're not always towing exactly the line of it. And again, that's why I think it's important to sort of think about this in conjunction with it, that when we're talking about what is a copyright violation, what are these things, we're talking in many respects about what is a technical violation, what is a specific violation of copyright, because that's the interesting question. And sort of in old law school terms, it's the black line rule. Where is the line that when you cross, it's a violation, when you don't cross, it's not. Recognizing that you may very well cross a line and nobody cares, but that's not interesting.
So, Kirk, I got an interesting hypothetical for you. Suppose you're an amateur artist and you do a painting that reproduces, I don't know, who's the guy that used to do all the TSR paintings? Elmore, I think?
Yeah, he's one of them, if I remember correctly. Yeah, that sounds right.
So you reproduce one of his paintings and you put it up on the wall in your apartment, and it sits there. It's not being displayed in public. It's your private apartment. That's
Arguably it is, because if you have anybody over, it's public.
Yeah, maybe. And we kind of talked about that with like Super Bowl performances. But so you put it up on your wall as a practical matter. It's never going to be detected. But then you have a friend over who takes a picture of you sitting on the couch, and there's your painting right behind you, and tweets out the picture.
And that picture goes viral.
Yeah,
now we have 30,000 copies of it, and you're the latest celebrity because look how good you are at copying artwork.
Not only that, when you tweet something out, there's a contract with Twitter, and you license them to reproduce the image you sent up, and you represent that you own the IP to it. So now what? We got a mess.
Yeah, and that's, I think, the simple answer in conjunction with the hypothetical is we have a mess. And again, I'm going to jump back to law school for a second. This is what a lot of times people refer to as the law school exam problem.
Exactly. Yeah.
If you take IP law at a law school anywhere, when you take your exams, they give you problems like this. And the idea behind it is
because there's no answer.
There's no answer, and there's a lot of issues raised. So
is it a public display of the artwork?
Is it a public
or is it
display?
Just incidentally captured? Because think about it. You take a photograph of a cityscape. How much IP are you capturing in that photo?
Yeah.
And are you violating all of those copyrights and all the architecture and everything else when you do that?
You've also got another issue here, which is the fact that you didn't actually take the selfie. Your friend did. So who actually created the artwork that's actually the violation here, which is the Twitter image? You get into these kind of weird issues.
Who's the violator? Maybe you as the artist violated by making the copy, but your friend publicly displayed it, not you.
And remember, there were two things about that. One is to make copies and one is to distribute copies to the public. You didn't distribute any copies to the public. Your friend did, and he arguably did so in violation of Twitter's user policies.
Yeah, like I said, it's a mess. So there's that. So even with something as simple as I'm just going to make my own picture and hang it in my apartment, here be dragons, as always.
And actually, it's a sort of amusing tie-in in conjunction with Here There Be Dragons. And I think that again, is a good thing to be thinking about with this. What we created here, people look at this and go, yeah, that's a really particular hypothetical. It's a law school exam question, stuff like that. But these kind of things actually happen a lot. So the example would be, and sort of, taking your sort of carry-on example, I'm going to put on a TV show and I need to have a particular piece of artwork in the background because it's referenced in the script. How do I get that piece of artwork in the background?
Or do I not? Do you replace it with something else? And you see this in TV. My wife and I were actually on an episode of the Great Food Truck Race when they were in St. Louis a couple of years ago. And they make you sign all this stuff. And anybody who won't sign, they blur your name out because they don't want any argument that they're violating anybody's rights. Now, that's more rights of publicity and whatnot. But you'll see it with T-shirts and stuff, too. They blur out academic logos and corporate logos to avoid any implied association.
Yeah, I know there's a big thing in Striver for a while because they were blurring out logos. And I think they forgot to do it on one episode or something like that, or one particular logo there was an issue with.
Well, this is a side issue, but the whole thing is weird, right? Because, one, I'm not even convinced you have to blur out the logos. Like, do people not understand how TV works? Give me a break, especially reality TV. But by blurring them out, then you have this problem where you create a false association where you forget to blur them out, even though there is none. Like,
yeah. And quite frankly, a lot of people can figure out what they are through the blurring, too.
Oh, yeah, of course. So, but going to the perhaps more interesting question, what if I went to draw or paint or otherwise produce art of something that's not a direct reproduction? So the example I want to raise is the character Glorfindel from Fellowship of the Ring.
Who's Glorfindel?
So if you're a Lord of the Rings fan, you're screaming at your radio, you know exactly who Glorfindel is. But if you're not,
that's why I had to ask.
A character that's in maybe 10 pages of the book at most, not all that well fleshed out. I think he has yellow hair. Maybe I'm going from memory here, but I've read those books 20 times. This tells you how well fleshed out this character is. Despite that, I couldn't tell you anything about Glorfindel other than he's a heroic elf that saves Frodo at the river going into Rivendell. So you paint Glorfindel. Unless you write Glorfindel down on the sheet of paper, how does anybody know that that's Glorfindel as opposed to any other generic Tolkien-esque elf?
Yeah, and I think that's sort of tying on that thing in conjunction with even saying Tolkien-esque elf. In many respects, a common popular culture perception of elves is Tolkien-esque elves. So
yeah, I guess Tolkien-esque isn't even really necessary as a modifier. Like most elves are by default Tolkien-esque. Yeah,
they have pointy ears, they're taller, and they're haughty. I mean, that's the sort of useful things I think you get into.
Yeah, so there's that problem, and that raises a couple different legal questions. So one, is Glorfindel copyrighted at all, other than to the extent that the literal words on the page appear in the book?
Yep.
And that's the character copyright question. Is there any copyrightability in that character apart from the description of them?
And we're definitely going to get into character copyright. Yeah. We've already touched with that in a future episode because that's such a big issue.
And the answer here is probably no. It's such a minor character.
Yeah, it's essentially no. But I think the thing that's interesting, and I just want to talk about is sort of a particular case in this area, is they've actually had cases that have made distinctions. And the particular character in this case was Sam Spade, who I think most people know as the detective, where the idea is that a printed work cannot really sufficiently define a character in the way a visual work can. So when we're talking about a character like Glorfindel, who I presume doesn't actually appear in the movies, I mean, there may be a character. I
think it may be like an additional scene, like he's in like the council scenes.
Yeah, but again,
he doesn't have the same role. They gave that to Liv Tyler's character in the movies.
But even is he that character, in the credits and stuff like that? But if we take the idea that he's not, let's just assume he's not in the movie, or there is a character we can come up with that's not in the movie. Do we have no visual depiction of the character? What's to stop you from creating a visual depiction of the character? Yeah, there's a description of them in words in the book, but I think the average person reading that, I can take two very good artists, give them both exactly the same description of what somebody looks at, and come with two different people.
Yeah, I mean, you could draw Aragorn and make him look nothing like Viggo Mortensen.
Yeah, I mean, for obvious reasons, Viggo Mortensen's a real person. I mean, that's the thing. You have to have an actor portray them. It must be a real person. I can portray something which is not a real person. You also have the issue of the fact, again, Viggo Mortensen's character, you're taking something like an elf or something like that. They have makeup involved as well. So the makeup has also changed their appearance and made them a particular way, and the technical limitations of makeup.
And what do you do with a character like Sauron, who, if you're not a big Lord of the Rings fan, is basically this this giant evil dude in I guess in armor?
Yeah, I'd say he's an animated suit of armor in some respects.
Yeah, I don't know if that's what's in the book or if I'm being influenced by the films, but there's very, very little description of the character. I mean, it's kind of weird. Like, Lord of the Rings is a bunch of people being menaced by an evil lighthouse.
It is like an evil two evil lighthouses, technically.
Yeah, but there are scenes where I can't take credit for that. And speaking of attribution, I saw that joke online at some point and it did tickle me. But like in the books, the character has virtually no definition whatsoever other than he is evil and he made a ring. You could draw or paint all kinds of depictions of what this character might have looked like or been like in corporeal form. And everybody who sees it will probably know what it is from context, but although that character is very important to the story, he's not that well defined.
I'm going to actually give you a really good example, and I think I'm going to pick one that's public domain just as what it is. What does Hamlet's father look like? I mean, he appears only as a ghost. We know he's a king of Denmark. That's about it. So presumably he has a crown in his appearance as a ghost or as not as a ghost. But what on earth does he look like?
Yeah, I mean, that's the thing with dramatic works is these characters are rarely defined beyond their actions on the stage.
Yeah, and so when we're talking about, and again, sort of beyond that, as to what it is, if we're reading Shakespearean work, I mean, at least we have a play in that case, but if we're just reading a Shakespearean work, how do we define what this character looks like, who it is? We really have no idea. We have very little explanation as to what they are.
So thought exercise, what color is Juliet's hair?
Yeah, it's a great example. I don't think it's
I just assume it's blonde. I have no idea why. I guess because that's what I've seen when I've seen plays of it.
It's probably some famous play in conjunction with it. Now, I think the other thing you definitely get into, in conjunction with that is where is Romeo and Juliet supposed to be placed? And at least, I think in Shakespearean plays, you have a pretty much clear setting of it's probably
Italy,
medieval
isn't it?
as well.
Genoa?
It's Europe. I mean, I think that's the thing we get into.
Well, Montague and Capulet. I mean, you can kind of geographically place the surnames, but
they could also be Spanish for that matter.
You're right. It could.
And so I think that's one of those where you get into these kind of issues that a lot of these things when we think about depictions, a lot of times the way we think things being depicted is because that's the way we first saw them depicted. It's not because necessarily the way they're actually described. I mean, to take a sort of really extreme example, and I think a very good one, I'm not sure that the vast majority of people in the Bible are described in any sufficient detail to be able to know what they look like. The way we've based their appearances is based simply upon period, what we expect people in the period to be wearing, what we expect them to be looking like. But we have no indication of their race. We have no indication necessarily of particularly defining features. In some cases, there may be something particularly defined, but that's it. Now we're talking about a literary work that's, thousands of years old. And yet we really have, everything we have is that literary work is not defining it. It's all the work that comes afterwards, which is giving us the appearance.
Well, let's assume that there is a copyright that subsists on whatever we want to draw. What are our other defenses for why what we're doing is not copyright infringement? And I think the clearest one would be that it's a fair use.
Yep. And I think in many respects it's a transformative fair use. And I touched on this in the last episode, and the idea of transformative fair use is that we've moved it so far beyond its original as to be something essentially entirely new. And the fact that transformative fair use is weird because a lot of times when I think about it, transformative fair use is almost saying it's no longer a derivative work.
But pretty much, right? Because the derivative work involves the concept of you're transforming it somehow. But if you transform it enough, well, now it's just something that's wholly new.
Yeah, it's not really derivative work anymore.
We're going to cover fair use on the Urban Legend episode too, but fair use is not a well-defined doctrine, which is to say it's not defined at all.
Well, it's a well-defined doctrine. Its application is not well-defined.
Probably a better way to say it. So if you go look it up, if you're curious, I think it's just Google 17 USC 107. That is where the fair use doctrine is codified. And what you see it say, basically, is here's the things you think about to determine whether it's fair use. Nowhere does it say fair use means X.
Yeah.
The closest it gets is it says, for certain purposes, something may be fair use. And they list criticism, commentary, reporting, and teaching.
Yep.
And in popular perception, fair use boils down to commercial or not. I can't tell you how many times people say, but I'm not selling it, I'm not making any money, so how is it copyright infringement? That is not the standard.
Yeah.
It's part of the standard, but it's not the whole
standard.
One
of 4 criteria, and that's the thing, you're saying 25% of what it is at best as to commercial, non-commercial.
It's a false dichotomy too, right? I mean, news reporting is a commercial activity. Most of our news reporting arms are for profit.
Yeah.
Movie critics are giving criticism for profit.
Yeah. And commercial doesn't even mean for profit.
No.
It's simply, it means commercial. In commerce. You can have a not-for-profit, which is a commercial entity.
So what they're going to look at is, they call it the purpose and character of your use. So in this case, you're making it, if you're going to hang it in your room, the purpose and character is, I'm practicing learning how to do art. That's education.
Education.
Right? The nature of the copyrighted works, we're going to look at it's a literary work compared to what you made is a work of visual art or graphic art. So there's the transformative aspect there. The third factor they look at is how much of the original work you have used. So in the Glorfindel case, you've taken one character that appears in 5 pages of an epic saga.
Yeah,
pretty minimal.
Pages, yeah.
Pretty minimal. And then the effect of the use upon the potential market for the copyrighted work, your drawing is probably not going to seriously diminish the appetite for Lord of the Rings.
Interestingly enough, that's where you get into some of the sort of weird questions is this effect on the market is what really is the market of the work? And in sort of modern world, I think this is something worth just thinking about. I don't think we're going to go into any detail here. Oftentimes, licensing is the value here. We know that from Star Wars. We know from a number of properties. You can say the market for the work of a movie is the sale of the movie, but in many respects, the sale is really the toys associated with the movie. What really is the market of the work when we're talking about an individual character and an appearance of it? Is your creation of a drawing of Glorfindel, Is that the market for the book, The Lord of the Rings, or is it the market for artworks of Glorfindel?
Or the movie, for that matter. Yep. I mean, if you're gonna pick something, say there's a scene that, like, movies often kind of fast forward and save some money by having a character just in the movie narratively describe something that wasn't actually shown because it would cost too much to film. Well, what if you go ahead and draw that scene? Is it based on the movie, or is it based on the underlying book?
Yeah, or is it simply a Santa Fair and the fact that you drew a large medieval battle?
Yeah, exactly. There are other arguments too. You can argue an implied license, which is, I should tell you, these are defenses, which means, and we always often say legal defenses are the last refuge of the cornered scoundrel, right? You have no valid argument at this point that you're not infringing, and you're just saying I shouldn't be held responsible for it. So if your leading argument in an infringement defense is fair use, then you're already up against it.
A lot of times, you get the joke of the old attorneys of, I didn't do it and you can't prove it. Even if I did, you can't prove it.
Yep.
This is not even those. This is saying I did it, but it's okay.
Yeah. So fair use falls into that category. Implied licenses like that. So a good example of implied license is, somebody posts something on, I don't know, like the November novel writing month, the NaNoWriMo. You ever done that? Where you try to spit out a novel in 1 month? I've started that every year. I've never gotten past day one. But you publish your content in a workshop environment. You're impliedly authorizing people to quote it, to dissect it, to break it down, to maybe even edit it. I mean, there's an implied license to do that there based on the context of the use.
You can also obviously have a copyright holder who would put something out and say, hey, I've got my book, rewrite the ending. I want to have a fan contest to rewrite the ending. There's an implied license to that, even if they don't necessarily say it.
And then probably the easiest way is to find, if the original content owner has some kind of fan fiction policy, like we talked about Paramount does for Star Trek, and just stick within the bounds of that, then it's easier to say, well, look, I didn't infringe anything. This is what they said I could do. And it kind of goes back to a license.
And a lot of times, in many respects, I think a lot of those licenses are to deal with exactly the fact that what is fair use is so confused. So a lot of times, and I think that's also a little bit where the commercial, non-commercial dichotomy comes in, a lot of those licenses specifically make the commercial, non-commercial dichotomy.
You can do all this stuff, but don't start making money off of it.
Yeah, and that's, I think, about where that comes into fair use, recognizing that really is somebody contracting outside of fair use, but based upon what they think fair use principles may allow or not allow.
All right, well, that's it for now. Next time, we're going to talk about internet urban legends. We're going to go over what IP, if any, subsists in these organic urban legends. This is the continuing story problem where person A kind of starts something and person B picks it up and it just snowballs from there.
Yeah, the natural creation where the idea is something that effectively becomes sort of well-known but is created, for lack of a better term, by committee.
And then we're also going to, on a unrelated but nominally similar note, dispel internet urban legends about the law and IP specifically.
And we're not going to dispel all of them because there's way too many.
Oh, there are so many. Okay, so if you have a question, you can ask us on Twitter at LGGPod. You can email us at lggpodcast@gmail.com. Find us on Facebook. Search for Lawyer's Guide to the Galaxy. If you like what you hear, give us a review. It helps other people find us. There's the music. It's time to go. So thank you once again to the official LGG Cantina Band, Lorem Ipsum and the Scriveners. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.